As mentioned in the previous clip, the Council of Europe exists of various instruments as well as bodies. Nonetheless, it is worthwhile to look specifically at the European Convention on Human Rights and at the European Court of Human Rights. It is by far the most visible, the most used, and therefore arguably the most important part of the Council of Europe system, and has also been described as the crown jewel within it. Based in Strasbourg, the European Court of Human Rights has jurisdiction over the European Convention on Human Rights and its protocols where those create rights. The European Convention on Human Rights, or ECtHR, was of course adopted in 1950, came into force in 1953, and is focused on civil and political rights very much in the way that we have been talking about it in previous clips. The fact that the European Convention only covers civil and political rights is sometimes cause for confusion and also concern. But of course, in this case, you have to remember that within the Council of Europe, we also have the European Social Charter, which in fact establishes and guarantees the various economic, social and cultural rights, and which is supervised by the European Committee of Social Rights, which also reviews collective complaints on alleged violations by state parties. It is a bit unfortunate that I have to relegate the European Social Charter and the committee to a side note in this clip, and I would encourage you to look it up and look up its very interesting jurisprudence. However, it also needs to be clearly stated that the decisions, the case law that come from the committee are nowhere nearly comparable in size and influence to what the European Court of Human Rights has done. Returning to the court then, the judges are nominated by the Parliamentary Assembly of the Council of Europe, and every member state of the Council of Europe gets one judge, which serves for a 9-year term. The judges are then assigned to various committees and chambers, to which I will get in a second, to review various individual complaints. But this is obviously not the only thing that the European Court of Human Rights does. In fact, it also possibly reviews interstate complaints, and there have been a number of those over the years. And since 2018, it can also issue advisory opinions if questions have been submitted by national courts and tribunals. That said, by far the most important function of the European Court of Human Rights has been to process and decide on individual applications. The way it has done so has changed over the years. Originally, there was a European Commission of Human Rights, which, quite comparable to the Inter-American Commission on Human Rights that still exists, firstly reviewed the applications and then possibly forwarded them or submitted them to the European Court of Human Rights. And in fact, the architecture of the court in Strasbourg reveals this kind of split, or these two bodies which were supposed in their specific wing of the building perform the respective function that they were assigned. This changed with Protocol 11 of the ECtHR, which came into force in 1998 and which abolished the Commission, thereby effectively giving the right to a direct application to the court to all individuals, which then didn't have to go anymore through the Commission to reach the court. This then is one major difference between the Inter-American system on the one hand and the Council of Europe system, and more specifically the European Court on the other hand. Next to the fact that the European Court consists of many more judges than before 47 as compared to the Inter-American Court. The reform of the system by Protocol 11 did have a profound impact, and in fact what it did, it so to say opened the floodgates to individual communications and applications, which continued to rise at a really high rate, leading to a backlog, so unprocessed cases at the court, of over 150,000 at its height in 2011. And you can see, of course, how this becomes a major issue for the court, because, as is often said, justice delayed is justice denied. And over 150,000 pending cases were really a sign of a more structural problem that had to be addressed and was eventually addressed in Protocol 14. 14, which made a number of changes that are illustrated in the following chart, ensuring, for example, that the committee of judges could not only declare cases inadmissible, but could also judge on the merits of a case where the decision was based on well-established case law. Protocol 14 also introduced a single judge panel where a single judge could strike out as inadmissible a decision of an individual. I'll get in a second to the various procedure hurdles and inadmissibility criteria that can lead to such a decision. That said, the more complex cases, so to say, are still being dealt with by a chamber of 7, which, if a case has particularly high stakes or raises particularly difficult questions regarding the protection offered by the convention, can also relinquish a case to the grand chamber of the court. And these grand chamber judgments are obviously some of the most high-profile cases, landmark decisions that also have received the most scrutiny and attention by scholars and legal commentators in the human rights field. For each application, the court in its various constellations will of course consider the admissibility and later the merits. And at the merit stage, we are of course confronted with questions such as what is the scope of a right, has it been violated, are there legitimate limitations being employed here by the state? But I would like to end this video with a few words on the admissibility stage, in fact. Because obviously, particularly in a case of there being an overload of the court, these admissibility criteria have become very important to distinguish which case is going to be considered on the merits and which one is not. First, in order for an application to be admissible, it has to be filed by a victim. And these can be direct as well as indirect victims. And indirect victims are, for example, family members, next of kin. But there is no such thing as an actio popularis or a collective complaint before the European Court of Human Rights. So in one way or the other, there needs to be an individual applicant or a legal person that has been in one way or the other affected. Furthermore, claims should not be manifestly ill-founded, which they are if they are undersubstantiated, so there is even prima facie no evidence for them, or if they are far-fetched. Applicants will also have to make sure that they, prior to going to the European Court of Human Rights, exhaust all the local remedies, which means that they need to have made their claim before the domestic institutions, which then should have dismissed it rather than giving it a remedy. Applications will also have to be launched within 6 months after the final decision has been made at the domestic level, otherwise the time limit will have expired, and that of course is sometimes regarded as a quite strict but nonetheless very important criterion. And finally, and this was introduced with Protocol 14 to reduce the caseload, there has to be a significant disadvantage, which basically means that the court, and this is in fact a rule that exists in many judicial systems, the court will not occupy itself with trifling matters, the so-called de minimis rules, which reduces the amount of trivial matters that the court will have to review. There'd obviously be much more to say about the European Court of Human Rights and its extremely rich jurisprudence also on the substance, but I'll leave it at this. I will now turn to the European Union and the way it has promoted human rights in its work.